welcome. We're going to have some fun today. And of course, like in the movie Harold and Maude, I have a perverse sense of humor. We have a slide deck that you've probably not seen too often for a 1 hour session of 140 slides. Tell you a little bit more about those in a minute, but we're not going to be tied to those. So you have those as a resource and a deep resource of all kinds of goods about the topic today. This is data privacy compliance. It's episode number 4 of the Financial Poise Corporate and Regulatory Compliance Bootcamp. Although if you've been watching these and participating, the Foreign Corrupt Practices Act, one that was supposed to be last Friday for a variety of reasons, didn't go. And so this is episode 4, but it's the third in the installment this time. You can read more about Financial Poise on slide 3, the sponsor and the main body that puts on these educational boot camps. Our panelists today, I want to introduce the 2 that are here, and then we'll talk about someone who unfortunately could not make it today. First, Lauren Silvestri Burke. She's at Morgan Lewis and Bokius LLP. Second, we have Kyle Miller of Denton's. And the third person that was supposed to be on here and today had an emergency, Jamie Wida of Bradley Arendt Bolt Cummings LLP. And what we'll try to do is, between the 3 of us, we'll try to cover for those things that she may have covered for us and that she had planned to cover but could not make today. My name is Dan Cotter. I'm a partner with Dickinson Wright PLLC out of the Chicago office, and we're in 23 cities or something like that. You can see our names on slide 1, and you see the 3 of us on there now. You can read our bios on slides 138 to 140. Neither Financial Poise nor we intend this to be an infomercial. You don't have to listen to me read bios. The bios are there. You can look them up at the firms they're at, or if you have questions, you can look at our bio slides and do more on that. About the slides, as mentioned, I may from time to time call our attention to slides relevant to what we're talking about. So you can take notes if you like. But don't worry if you're listening but not watching this webinar. You'll be just fine because the slides are not critical to this discussion. It's really going to be, I think you're going to really enjoy Kyle and Lauren's perspective, both very seasoned in this arena. And it's been a joy getting ready to prep for this session with them and learn more about them and their expertise in a whole variety of areas. Thank you to our co-producers. In this case, co-producer, the National Law Review. You can read more about the National Law Review on slide 4 of the deck. Financial Poise webinars are supported in part by sponsors. And again, the sponsors for this webinar is the National Law Review. And more information, again, is on slide number 4. The last thing before we begin, slide 5 contains the disclaimer on behalf of Kyle and Lauren and myself. You are not our clients, wherever you are, whether you're in an organization, law firm, or anything else. We're not your lawyers. What we do here today is for general education and not for you to act on without appropriate advice. If you have questions in the privacy arena or any other corporate or regulatory bootcamp arena, make sure that you consult with counsel that can assist you in those things. And as you'll hear today from Kyle and Lauren primarily, this is an area that has it's a patchwork and it's got many elements to it. It's like an onion, you peel back layers. And so again, when you are doing things in this bold, brave world we're in, make sure that you consult experts like Kyle and Lauren for all of your needs. Without further ado, here we go. And we've planned a number of questions. And again, I'll make the introduction. All levels of society rely upon information technology systems. Network operations are pervasive and impact nearly every aspect of our society. The desire of companies to collect, use, store, and secure information about customers, employees, and other individuals is a requirement of the new economy. Although you could go back to early in my career, I was at insurance companies, and they were collecting lots of data back in the 70s and 50s and 60s and 70s and 80s. It's no wonder that the prevalence of electronic communications in a growing economy, the growing dependency on cyberstructures and operations also create potential vulnerabilities to cyberattacks. It's critical to preserve information systems and address and prevent weaknesses in cyber protection efforts. And so this webinar is really going to look at the means for companies to reach data goals ethically, efficiently, and legally, and talk about a lot of why we should be concerned, who should be concerned, and what aspects and what arenas we should be concerned. I'm going to ask the panelists to provide a quick introduction into regulation of data privacy and protection, the various types of data to consider in this context, the threats to be aware of, and key relevant laws in the United States, as well as foreign laws a little bit, most relevant to U.S. companies. We'll maybe touch a little bit on GDPR, but we're not going to focus on that today. We'll review the regulatory landscape with a focus on regulations and other issues specific to some key industry sectors as we examine the commonalities and differences in how data privacy and protection are addressed in different contexts. So with that, we're going to turn to our first question, and Lauren will take it away. Lauren, what type of information should we be concerned about protecting?
Thanks, Daniel. I think that's a great place to start any conversation about data privacy. What kinds of information are we seeking to protect? It's important to kind of take a minute and understand what is this targeted information so we recognize the weak points that may expose us to a cyber attack. I like to think about this data in a few different categories. First, personal data. So here we're talking about personally identifying information, or you see PII, the term, which includes things like your name, your birth date, your social security number, driver's license, passport numbers, usernames and passwords. So that's kind of the most targeted data and tends to be what comes to mind first when we think of a cyber attack. A recent cost of data breach report found that 80% of breaches are going to affect that sort of customer personal information. The next category is client data and material non-public information. So this is other people's personal data that may be in your possession. Here we're thinking of things like customer list and trade secrets and pricing information, employee data, confidential data that doesn't belong to you, but is in your possession and control. Third, we think about cloud environments and sort of source code repositories. So this refers to things like software archives, web page visits, SNP data, things of that nature. And finally, as a separate category, infrastructure. And so this often includes government data that's involved in infrastructure systems, such as electric grids or water supply type information. So much of this information is protected by legal and regulatory requirements or contractual or quasi-contractual obligations to keep this data private. I'll just briefly mention a few of the sources for those requirements. I think that was sort of part of this kickoff. So first, we have information that's protected by law, so either at the federal or state level. Those may include the Federal Trade Commissions Act, HIPAA regulations, and other sort of state privacy law. Next, we have industry-specific or regulator-specific requirements. For example, the New York State Department of Financial Services, cybersecurity requirements, payment card industry, PCI, and data security standard protections. Next, we can think about obligations to others to keep information confidential. Those are more like contractual obligations. Maybe these come up in the customer type setting where someone provides personal data and you're under a contractual obligation to protect that in the course of your business. And finally, obligations to keep corporate information private. So, for example, trade secrets and confidential customer list.
And again, it's I think as we increasingly use the internet and do things, I think some of the information you talked about, the state privacy laws and things, it gets pretty granular into pixels and gets into biometric information and genetic information and all kinds of other things, which just really makes it even more complex, and it makes it hard for that average person to, actually, for companies to comply. So let's turn to the second question. And again, Kyle, unless you have anything to add, we'll ask the second question of Lauren. And
sure. Well, I was going to add the specific areas that Lauren's was discussing to protect against are absolutely high risk as it relates to your obligations in the event of a cyber attack. But we are seeing broader types of information that must be governed, if not protected, in the traditional cybersecurity sense, as it relates to the privacy laws. So we're finding that a divergence between the cybersecurity requirements and the privacy requirements, though they both require attention and governance.
Excellent point. Excellent point. And it's really, yeah, it's really gotten to be much more complex than probably it ever was at any other time for a lot of reasons that you just mentioned. So, Lauren, when we talk about data privacy in terms of data protection, what threats should companies be concerned about?
So we're seeing an extraordinary active data breach and cyber environment just in the world we live in today, with an uptick in ransomware attacks and other cyber crimes and data security issues. Those are all on the rise, and you hear every day on the news that another company is the victim of a cyber attack. And the consequences of those attacks are complex and costly, for both an organization's reputation and for the bottom line. So it's really important to sort of think about the common attacks that are out there that need to be on your radar and you need to be prepared for. Um, we sort of group them into four categories, and each category kind of has a bunch of layers to it. But first is social engineering and phishing. So this is like a typical con or some sort of trickery to manipulate a user into making security mistakes or giving away sensitive information. So this attack usually happens in a few steps. One, the perpetrator will plan an attack, identify the victim, gather background information on this victim. And again, a lot of this is available just through social media platforms and other sort of areas on the internet. And then the perpetrator will select the attacked method. Often there's a sort of a period of the attack where there's a move to gain the victim's trust, and then deceit, and the victim just provides the requested information to the perpetrator. Second, ransomware cyber attack and cyber extortion. So this is a type of malicious software that will encrypt a victim's files. The attacker will then demand ransom from the victim to restore the data upon payment. So users are kind of shown instructions as to how to pay a fee and get that, the key to reaccess data. Third, network interruption. This refers to an impairment of the organization's network. So the attack will disable a company's entire network, which really can be capable of shutting an entire business down, resulting in loss of income and the ability to operate your business. And finally, hardware attack. So this is exploiting a computer system through remote or physical access to a company's hardware. And that can often be the result of some of these other attacks we've discussed. Just from a practical perspective, I think it's important to keep in mind that most cyber attacks are carried out by professional cyber criminals. So a victim company should not attempt to sort of take on these groups without competent support from professionals. It's often too that these criminals are repeat players and sort of have a very targeted, well rehearsed attack that's worked before. A few sort of concrete things to mitigate that risk is engaging outside legal counsel that's better experienced on cybersecurity, together with forensic experts. Have sort of a team in mind that's lined up and ready to jump in if you ever are the victim of an attack. And just sort of being proactive and just having a comprehensive risk management program that's focused on preventing your system from being attacked and having adequate security mitigation practices in place.
Well, that's great. And again, the hackers have gotten much better in recent years. A lot of these hackers get into companies' databases, as Lauren said, either they build trust or they're embedded in there and it's not known for some time. They tend to lurk for long periods of time, sometimes now. And then by the time they actually do the ransomware attack, very hard to trace and find. And we see that more and more often with clients that will call and have experienced a breach. And as Lauren talked about, these are professionals. They're very skilled at finding ways to get in. And once they're in, again, they can lurk for months or weeks or whatever time period they want. They sometimes will erase their tracks, so it's very difficult to find the root cause of the attack. And again, when you think about your typical organization, it has tons of different entry points, tons of automation going on, and so it's very, very difficult to really understand and respond to these attacks. As Lauren said, you want to make sure that you get forensics involved immediately. You want to make sure that you get talented counsel involved for many reasons, including establishing a relationship so that there's some potential umbrella for privilege while you're trying to get to the root cause of some of these things. It's very important. We'll talk about in a couple of minutes cyber insurance, but oftentimes the carriers will have panel counsel that will be appointed to respond. But you want to make sure, if you've got other counsel, that's your outside counsel, that you engage them as soon as you know something's happened so that they can at least take first steps to protect you. So, Kyle, anything to add to that?
Yeah, I'd just add that we're seeing an increase in the number of attacks fueled largely by the availability of generative AI. So, like exactly like Lauren said, the phishing and social engineering is a common attack vector. And we used to say, well, look for misspelled words and short, urgent emails. But now
Yeah.
generating long emails at scale is trivial. And so on defense, we have to be perfect 100% of the time. The attackers just have to catch us sleeping once. But the misspelled words, the grammar mistakes, the level of professionalism in the communication are now much higher because it's much easier to do at scale and generate thousands and hundreds of thousands of these messages at once that can still be targeted and still go out to companies. And that's just with text. I've worked attacks where it seems that they were using voice cloning based on available voice prints online, and I've certainly seen demos, though I personally haven't seen in the wild, video image cloning as well. Then if that's just around the corner. So the I don't know if it's the level of sophistication has increased, but the tools commonly available to these threat organizations that Lauren mentioned are allowing them to level up in a way that affects all businesses of all sizes.
No, that's exactly right. And like you, I've seen and heard from FBI people and others about the AI. There's a story of a lady who was requested to transfer a large amount of money by the CFO. She thought it was strange. She got on a Zoom call with what looked like to be him and was him, and lo and behold, it was deep fake uh, and resulted in a large transfer of money. And we're seeing that more and more. And again, I don't know if the technology is better or if it's just that things are, there's that ability. You mentioned Kyle text, and it used to be the emails, and even a few years ago when those emails were horrible grammar, they had misspellings. it's interesting how many and how often we saw people respond to those and be hacked. And so now, like you said, I don't know if it's state actors. I don't know if it's just better hacking groups, but much more professional. It looks like real things. These watering holes and other things that we see. It's really the rate at which it increases is just phenomenal to me, and it really makes me wonder in a couple of years where we're going to be at with the technology and with kind of how this all operates. So let's turn to some high-profile breaches in the retail space, such as Equifax, Yahoo, and others. If one of you wants to walk us through a few of those data breaches and their implications on risk management, and we're not going to spend a lot of time on this. This was a Jamie question, but I figured we would ask it since it's in the script.
Well, I think that the one of the biggest takeaways of the Yahoo incident, that I think everyone on this call should be mindful of, is that the entity that disclosed that data breach, disclosed it after acquiring Yahoo. And while the threat actors were in the systems of of Yahoo, there wasn't breach notification, there wasn't discovery, until the company had been sold, and the acquirers of the company were then stuck with discovering the breach, realizing that they had disclosure obligations, and ultimately stuck with the penalties that were associated with it. So while you can protect your company by at least mitigating your risk by implementing strong security controls, you need to make sure that you're doing the appropriate due diligence on companies you're looking to acquire, because you may acquire a significant risk around data security. Even if you're planning on bringing them under your controls, you might be liable for something that happened to that organization in the past.
Lauren, want to add anything to that?
I would just kind of echo those points. I think those are all good observations. Another thought I had on before we moved on to this question, but just on the sensitivity of the timely response to these attacks. With these wire transfers, if you do catch things very quickly, you can get to a point where you get ahead of the funds actually being transferred. But usually it depends on the bank and whether it's international, but where it could be talking 24, 48 hours could make the difference of the money actually leaving hands, and it just being able to be kind of clawed back without any damage done. So it just sort of underscores the importance of attacking this head on as quickly as possible.
Yeah, and you raise an interesting topic that I don't think we're necessarily going to cover in our questions, and that's this whole concept of the federal government's views on ransomware and payments of ransomware, and making sure that you're not out of whack with the Office for Foreign Asset Control and other regulations. But in a lot of these large breaches, my former employer, CNA Financial, I think still might be the biggest ransomware payer. And they made a conscientious decision. Either you can be frozen and not be able to operate, or you can, in some cases, make the payment and then move on with your life. And that's, like a lot of decisions, it's not an easy one, but it's, again, if you're in a situation, you want to make sure that you're talking to your lawyers and talking to the federal government and the FBI and others to kind of make sure that you're not running afoul of somebody that's on the OFAC list, or some of the bad actors are on that list now as which has been around since 1950. So you just want to make sure that you're not running afoul of that. All right, now I want to turn to something I think that's a big issue, and that has to do with the issues that businesses are facing relating to social media. And I think one of you is going to start off. Is it Lauren? And then Kyle is going to continue, or is it vice versa? So take it away.
Lauren can lead us on this one.
Yes. So social media is it, something that I think everyone has a lot of exposure to, and just the amount of data that is voluntarily put out there sometimes is well, it can be surprising, but cyber criminals are very aware that that is a great source to look for their next attack. So I think the prevalence of social media really can't be understated. Whether we like it or not, it's become a big part of everyday life with the use of apps like Facebook and Instagram, and then in the professional world, LinkedIn, and then others that I think I sort of aged myself in my familiarity, but Snapchat and TikTok and the list goes on. So we've grown sort of accustomed to sharing private information on these platforms. And the reality is that this sensitive user data is at risk. By way of a quick example, in 2022, July 2022, Twitter was hacked and 200 million user email addresses were posted on the internet. So those leaked email addresses gave the bad actors the information they needed to conduct additional lines of attack. So what kind of information do we need to think about protecting here and like in the social media world? So we think about the information that we voluntarily share, which is oftentimes very private information. Sometimes in privacy settings on these platforms, you have the ability to restrict what can be shared with certain groups. So that's sort of one category is the information you're putting out there into the world. And then the second is information that's being collected about you as the user through tracking devices. So, your interests, things that you are sort of looking up online and engaging with, and then your locations, which sort of track this digital footprint that you're forming. So there's a few unique privacy concerns that these platforms present, and I'll hit on a couple of the big ones. Data mining for the identity of users. So scammers will use this publicly available information to sort of target their cyber victims and develop their line of attack. There's also the privacy settings that I was referencing, but users need to be aware of sort of the gaps and loopholes in these privacy settings that allow more of your information to be shared with a broader group that you may be intending. And then finally, that location tracking on your device, which really, beyond a cyber attack, just tracking where one is located and that sort of opens you up to attacks even beyond the cyber world. So social media companies are facing a lot of pressure to increase these privacy protections, but the cyber criminals always seem to be kind of one step ahead in anticipating that. So Kyle, with that, do you want to talk about some of the recent attacks here?
Yeah, so not an attack, but you talked about how there are controls in place to limit information being transferred, and sometimes gaps in those controls, and those gaps led to an enforcement action hot off the press yesterday. The state of California, through their attorney general, reached a settlement with Healthline Media LLC. It runs the website healthline.com. And so it's a $1.5 million penalty about how it implements those controls and transferring personal data to third parties, including social media companies. So about the company generally, I think it's important to know that in their complaint against the company, the California Attorney General says Helloline does not solicit health information from their visitors. They don't get diagnoses. They don't get visitor medications. It's not a healthcare provider, and therefore doesn't have to comply with health privacy laws. Instead, what it has is educational articles about about certain diseases, about individuals' health, and it serves advertisements against those articles. And in doing so, it uses what I think are common ad tech technologies, including cookies and pixels for from these social media companies, so that when that they can identify when users have been on their site and users who are likely to want to see their content. Their articles that the Attorney General called out in the complaint could include articles that would be called something like newly diagnosed with HIV, important things to know, or things to know about your new multiple sclerosis diagnosis, general information for diabetics, and things like that. And what the Attorney General alleged is that when individuals were going to the website and viewing these articles, those article names were being sent to social media companies, advertising companies, quite a few different third parties, and ultimately ended up in the hands of data brokers with the identifying information of the people that were viewing these articles. Really interestingly, um, the uh, the Attorney General recognized that in their privacy notice, this company uh, said that they'd be sharing personal information uh, with third parties, but the the Attorney General didn't think that that was sufficient, because under the California standard, the transfer of data has to be consistent with the reasonable expectations of the consumer, and thought that a reasonable consumer viewing a website about how to treat diabetes wouldn't then assume that social media companies would be able to set a flag next to their name saying, well, this person is likely a diabetic. They had purported controls in place that the Attorney General alleged didn't work. So that they had opt-out mechanisms, but they weren't configured appropriately. And that when people went to opt out via the cookie banner or the global privacy control, which is a setting that that users can set in their browser, the website wasn't responsive to those opt-outs. This is actually the third enforcement action from California we've seen in the last few months around misconfigured opt-out mechanisms. So if your website says we use cookies, accept, reject,
Hmm.
and the users, when they're setting their preferences, having that tool is great, but if it's not doing what it says it's doing, if when they say no, do not track, the some of their data still goes to a social media company, then there's a risk of enforcement under quite a few state laws, but certainly California, because we've seen three of these in rapid succession. So so businesses using any form of advertising technology, including those social media tools on their website, need to review their compliance program and get firms to come in and audit to make sure that the data that's being handed over from users when they access your website and your app is not just consistent with your disclosure, but permissible under the law. Because under this new enforcement action, as of, I believe I said yesterday, but that's July 1st, 2025. Even a notice that this data was going to be transferred to a third party may not be sufficient if it's not what a reasonable consumer would expect to happen.
And I think you raise a very important topic, is and one that I spend time with my clients on at times, is really kind of a holistic view of the whole process of data, from what they're collecting to what their internal policies are on storage and safety and security, to what they're telling the public is actually happening versus what's happening. And if you look at the Federal Trade Commission, for example, and their website, they track all the data privacy settlements and things. CCPA does the same thing now. They've got the privacy czar out there. And as Kyle was just talking about, a lot of this is like cookies and pixels. You say that you're doing certain things. There's tracking software, and sometimes when you can opt out that it won't track you when you're in stores or in certain locations, but it's still tracking. If you have an iPhone, you can look and there's a history of where you've been. You can disable, but again, there's all this stuff. And one of the biggest uh, hurdles, I would say, or potholes in the road of privacy is kind of this mismatch. And even as Kyle said, even when somebody's technically compliant with things, seems like it's a no issue. The thing I think that all three of us would agree on is that when it comes to regulators, the New York Department of Financial Services, or Texas AG, or Illinois private rights of action, that these are taken seriously and that there's big money at stake if you get wrong or there's a disconnect between what you're telling people you're doing and the data you're collecting, and violations of same. You-
That's Yeah, that's exactly right. And under these emerging state laws, the rule under the FTC used to be you must do what you're saying you're doing. And so we said, all right, well, let's make sure we disclose accurately. But under the emerging state laws, there's affirmative requirements. And
Right.
it's not just about what you say you're doing, but you must do these things and give the data subjects specific rights to their data. And there seems to be little room uh, for for operational non-compliance. You must do at a minimum what the law states.
Absolutely. And that's kind of a nice segue into the next question that I guess I'm going to handle, unless you have anything else on social media. But it's what role cyber insurance may play in developing or reviewing a data privacy compliance and risk management program. And we'll give a brief overview of the cyber insurance landscape and how it's changed in recent years. So the first thing I want to talk about is that cyber risks a lot of times fall through gaps in traditional policies. Companies of any size have a commercial property, business interruption, commercial crime, comprehensive general liability, D&O, E&O. But the thing about those is oftentimes they don't cover because it's not something that's intended to be covered by those policies. There's also the kind of the flip side of that. Some of you, or maybe all of you, have heard of silent cyber. And the thing about silent cyber is that in certain instances, there may be some kind of fact pattern where it really wasn't intended to be covered by a policy of insurance, but it ends up being covered. And the example I give, I'm from the state of Illinois, and until 2024, each instance of a fingerprint or face scan under the Illinois Biometric Information Privacy Act was a separate incident. There was an exclusion for regulatory uh, statutes, and it talked about uh, junk facts. It talked about TCPA. It talked about a few other things, but it didn't talk about kind of these collection things where there's really it's not the breach of the data, it's the not having consent and things. And so that's been a change over the years to the CGL policy. Um, when it comes to cyber, I think that the thing, again, I advise people to do is just like in the privacy arena, when you have a breach or other issues on privacy, consult with somebody that really knows the policies and understands them. And why do I say this? Because there's no two carriers out there that have a common policy when it comes to homeowners or auto insurance, there are filing agencies. There's some cyber that is common, but it's very much a cafeteria plan of buying, and it can have sublimits for notices. It can have sublimits for remedies such as credit monitoring. It can have reputational harm. It can have restoration. It can have all kinds of things in it. And there's two real pieces. Most policies are either property or they're casualty when it comes to for companies. But in the arena of cyber coverage, there's first party coverage, and those first party costs are the data breach and response costs. We talked earlier, Lauren talked about, and Kyle talked about making sure you get the right forensics people in. Those forensic people cost money. They're, and depending on the carrier and stuff, they may be fixed fee or limits, but that can add up very quickly in terms of forensics costs. Like we talked about earlier, the hackers have gotten much more sophisticated, and so they know better how to hide, and it's much more difficult in many cases. It can take days, weeks, or months in some cases to fully identify what the root cause of the issue is. And so first party coverage is intended for those things that the company itself is incurring, and that needs to be covered. And again, you need to look at the sublimits. You need to look at the policy language of what's an insured act, what's actually in the insuring agreement, because again, definitions are going to be different. There's going to be different standards. There may be different pieces and parts. And again, these policies, I reviewed one a few weeks ago, probably like 65 pages with endorsements and all kinds of other pieces. So it's very crucial that you understand what exactly you do have or don't have and what gaps you're filling. Then there's third-party coverage, and this is for third-party liabilities. It's data breach related litigation that occurs. Again, the fines and penalties that Kyle just mentioned, but there's also litigation over, all the big social media platforms have been sued repeatedly for violations of pixels, for violations of BIPA, whatever it is. And so those can be very costly as well. See if the defense is within limits or outside of limits. There's class action litigation often in these cases. There's fiduciary duty violations under corporate law and related issues. And then there's cyber-specific coverage that can be, again, for ransomware and for other types of direct coverage. When balancing the cost and risk in the context of a data privacy compliance program, and if you're under some regimes like the New York Department of Financial Services and you're a covered entity, you have certain responsibilities already to make sure you have a robust program in place. But insurance coverage should be part of the analysis. The reality is that these losses are too big to be fully insured in most cases. The target was, cost them, I forget how many dollars back in 2013 or 14. It's hard to believe that was a decade ago. That the HVAC system was the port, but they had $100 million of coverage, and that was not even close to covering it. But on the other hand, some of these defense costs, you want to have the ability to hire a forensics person. You want to have the ability to hire counsel that's within the policy. And so again, you really need to take a look at that and be very careful. What does the landscape look like? It's been an interesting market, I would say, because up until probably 5 years ago, maybe less, the insurers would not really look at industry. They won't really want to look at as robust of a due diligence process. You could apply for the coverage, answer some simple questions, what kind of data you had, and then you would be priced. What's happening nowadays and conversations I have with folks is that they're looking at things like multi-factor authentication and making sure that that's part and parcel of everything you do, whether it's a nonprofit or for-profit, that you have multi-factor authentication. They want to look at your privilege access and how tightly you control what data can be accessed or manipulated by anyone. And they look at a lot of other things now. It's a much more rigorous process, and it's more time consuming, I think. And the reason for that is because as some CEOs of insurance companies have said in the last few years, this may be a risk that's too big to insure. Just because, again, the prevalence of these bad actors and the ability to do bad things and score bigger and bigger ransomware makes for a very costly process. So unless Kyle or Lauren want to chime in on insurance, we'll move on to the next.
One thought really quickly,
Yep,
on
please.
just the importance of kind of getting ahead of the breach here. This is your time to kind of talk to your broker about what's available on the market. It's not the type of policy that you want to just keep renewing without taking a hard look every year at how the market's evolved and how the coverage available to respond to the evolving risk has sort of developed, and make sure that you have, you're already buying the coverage anyways, and make sure you're kind of buying the best, you're getting the most bang for your buck with the policy that you're putting in place. And then also, if you have specific providers that you want to be able to use in the event of a breach, try to get those in to your policies. So if you are under attack, you have the team that you want in place, not the team that your policy is going to dictate. So you have a chance to get involved at the sort of at the outset and at the renewal period. So I think it's important to do so.
No, I think those are excellent points, and I agree with you fully. And again, it's make sure that you're not skimping on it just because you might get a policy that's a little bit cheaper, but in the long run is going to cost you more money because it doesn't contain the bells and whistles you need. So let's turn to, with the different approaches that we discussed earlier, how do U.S. companies balance both the U.S. and the EU regimes? And please address the main challenges for U.S. companies under the GDPR. And this is for Kyle.
Yeah. So the U.S. patchwork that you referred to is becoming more cumbersome. Individuals in many states are getting more rights. The risk to businesses is increasing as it relates to data governance. But the the scope of the GDPR is still broader than anything we see in the United States, and that goes fundamentally back to the EU treating privacy as a human right. And if you're going to treat privacy as a human right, it leads to outcomes that we don't find in the U.S., such as a broader scope to the definition of personal data. While most states will say, well, personal data won't include data that's otherwise publicly available or has otherwise been disclosed. You don't find that sort of exception in the GDPR. While most states won't have specific protections for employee data or commercial data, what they might call B2B data, data that was voluntarily disclosed for a commercial transaction. You don't have that sort of exemption under the GDPR. And you all have talked a lot about security, and I've talked a lot about privacy, because in the U.S., our frameworks for the two are different. The CCPA covers privacy in California, but their data breach statute is different, right? The definition of personal data for privacy purposes is very broad in California, but the definition of what would require notice, what sort of data would have to be unlawfully disclosed to be called a data breach is much more narrow. We don't have that in Europe. So when we work security incidents for companies with operations around the globe, we usually find that in jurisdictions, certainly in the United States and others set up similarly, there's a lot of types of data that we may say, well, that was exposed, but that doesn't require a breach notification necessarily. Then we get into Europe and say, okay, we have to not only notify individuals, but also the data protection authorities, the regulators around this incident. And so companies are often looking to find the least common denominator and say, all right, like which standard can we just pick from and say, okay, we're going to comply with that, and that's going to help us comply with everything. GDPR is still the broadest. However, there are still requirements throughout the United States that are unique and not found in the GDPR. So you still have to build a comprehensive program based on everywhere where you're all the laws that you're affected by, not just the GDPR, though it's a good place to start.
Absolutely, and I agree. And different laws. The CCPA has been referred to as GDPR light or like it. The root of all these is the OECD in 1982 came up with 7 principles, and kind of it's a skeleton. But as you mentioned, there's different permeations, and I think that's what we're going to talk about next is kind of recent legislation, what's new in the space in the last few years, where we're at with that. And why don't you kick us off, Kyle, and then I'll chime in with some other thoughts as well.
Sure. So, in the wake of the GDPR, many countries around the world adopted similar requirements, and in the absence of the U.S. federal government doing the same, the states started picking up the slack. And today there are 19 states with so-called comprehensive privacy laws on the books. They're not, like I said, as comprehensive as the GDPR. They'll usually have processing standards or thresholds to try to keep small businesses from being affected. There'll be types of personal data that'll say, well, we don't necessarily regulate that. But they are far broader than any of the historically sectoral laws that we've seen before. So if you're listening to this and your organization is not in a highly regulated area, you're not a covered entity under HIPAA, you're not a financial institution under Gramm-Leach-Bliley. If you operate in one of these 19 states, you likely have actually more compliance requirements around how you process personal data than many of those financial institutions or healthcare companies, because these newer laws give individuals rights to their data, and restrict the rights to companies around data. If you're in one of these laws, really for the first time in the United States, states are saying that companies don't have complete ownership over the data that relates to identifiable individuals, at least not vis-a-vis the individual. So while there are 19 states with these laws on the books, they're not all in effect just yet. Some are coming into effect later this year, some the beginning of next year. And there are more states considering these laws. I feel like every year that there isn't a federal law, we're going to see another one of these broad laws. California has historically led enforcement here under the CCPA, and we just discussed the newest one yesterday. But Texas is really, I don't know if it's a close second or the leader for this year. Has been very aggressive in their enforcement of their comprehensive privacy law. I'll also say that this patchwork, while it is overlapping, there are gaps. There are areas where you might expect to find regulation where there isn't, and there are areas where nearly every state has something unique about their requirements. And just as a brief example, some of these statutes will carve out of their enforcement. They'll say this statute doesn't apply to organizations that are covered under the Gramm-Leach-Bliley Act. Some of the statutes say this that their law does not apply to companies that are covered under the Gramm-Leach-Bliley Act or those companies' affiliates. Some, such as California and slightly differently Oregon and soon Connecticut, regulate the entity. They say, well, if you're covered under Gramm-Leach-Bliley, the specific data that's governed under the Gramm-Leach-Bliley Act, this act doesn't apply to, but all other data doesn't. So for a financial institution under the Gramm-Leach-Bliley Act, such as a company that offers personal insurance, you look at this patchwork, and in some states will say, well, us and our affiliates, this law doesn't apply to. In some states, some of the data that we have is GLBA, but a lot of the data that we have is actually under the state comprehensive law. And Texas recently filed suit against a large insurance company, a conglomerate where they filed suit against 6 entities, legal entities that were all affiliated under this insurance company, 3 of which offer insurance, and so they the Texas Privacy Act doesn't apply to them. 3 of which were really technology companies or data companies that served this insurance company. And because they don't have that or affiliates exception, they brought the claims under their Data Comprehensive Privacy Act against those companies, and then UDAP claims against the insurance granting organizations that are entirely predicated on the Texas Comprehensive Data Privacy Law. And we'll see how that proceeds in the court system. But that's just one example of many of how there are seemingly small but highly consequential variations in each one of these laws, and determining. I think the first step for any organization is determining which of these laws apply to them, and then building a compliance program around them.
It's a great analysis of it, and again, it's ever changing. Like you said, there's differences. One of the challenging things is that every state has a different threshold for how many customers. And again, that's very hard to track because we have .com, we don't have .va, .il, and so telling where somebody's from is very difficult. That's part of it. There's different thresholds for size of companies and size of business. There's in a few states, Colorado and California, there's neural data, which is heartbeat and other kinds of data that's brain driven. That's now being a big focus. And you also have, combined with this, Texas passed the TREGA earlier this week or last week, the Texas Responsible to Artificial Intelligence Governance Act. And you say, well, that's not privacy, but it does. It's a lot of it is intentional misuse of AI, and what is AI in some cases, not just high risk AI, but it's again, it's looking at what that information is with the public. The one thing that also this emerges, there's no 50 states panacea yet, but there is the privacy breach notices that you mentioned earlier. There's all 50 states now, but there's now 20 states that have comprehensive privacy, and I forget what the most recent one is, but it's ever changing. There's always a lot of bills injected, and so again, it's real patchwork. It's real difficult for companies to comply with different definitions of personal information, different definitions of all kinds of things. And so again, you want to make sure if you're doing business in those 20 states that you are paying attention to what the changes are and where the landscape is. So with the last 2 minutes, I want to ask you each to talk about a best practice that you think is particularly important for your clients to keep in mind as they consider their data privacy compliance strategies.
Sure. My kind of piggybacking off of what I already shared, but I say get ahead with your insurance, have good coverage in place, figure out where you may have cyber related coverage under other insurance policies in addition to your cyber, so that if you are hit with an attack, you can seek coverage from all different angles. And work with your broker to make sure that you have the best coverage in place, conducting the risk benefit analysis and making a business decision as to where to put your money. But it's, in the case of an attack, it'll be money well spent.
Well said. Kyle?
Thank you all.
Yeah, I would say that get used to continually putting resources into your data governance programs and compliance programs. Daniel, you said several times this presentation on different topics, this is more complicated than it's ever been. This is riskier than it's ever been. And I think that I'm sure we could have said that every year for the last decade. And there are companies I work with that where they say, like, why do we have to update the data map again? Do we need to look at the privacy notice again? We just revised it. But not only do the rules keep changing, your organization keeps changing. And just as you grow, you're going to need to grow your human resources department. all sorts of, you have to manage all sorts of risk on an ongoing basis. And data governance is certainly going to be one of those that will require constant attention.
And yeah, my final thought would be the two things Kyle and Lauren said, and again, make sure you're not skimping on this as part of your risk ERM framework, because cyber is one of the top, if not the top, risk for most companies these days. Audience, this concludes our webinar. Thank you for joining another entertaining yet educational program of Financial Poise. Help me in thanking Kyle and Lauren for their excellent input and insights. The hour flew by. I think we could have probably been on here for 2 hours and still had topics to talk about. Look for Financial Poise webinars wherever better continuation education webinars are sold. And with that, we're bid you adieu and a happy 4th of July.
Thank you all.